It's again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
There we are. Welcome back to the Think Tank. So I want to go over a document I found really interesting. So it is in the Richard Allen case, and this is the second motion to dismiss. And this is based on what they're saying is newly discovered, destroyed, and missing exculpatory or potentially useful evidence. It's a 20-page document. And I thought, let me see if I can, there we are, make it a little bigger for you. I thought we should go through this, guys. So like I said, this is his second motion to dismiss. We did go through the last one, and it is in the Delphi playlist. So this is the state of Indiana, the plaintiff, versus Richard Allen, the accused. Discovered defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. What a mess, you guys. What a mess this case is. I heard Becky which is Libby's grandmother, was having a really hard time the other day, and they are so in my heart. Okay, so come now. The accused Richard Allen by and through counsel, Alex Baldwin, but no, Andrew Baldwin, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12, of the Indiana Constitution and Indiana Code 35-34-1-4A11, moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards set out by Brady versus Maryland. In support of said motion, the accused states the following. Number one, that on February 7th, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. 2, in his first motion, the defendant detailed how a February 17th, 2017 interview of third-party suspect Brad Holder was destroyed while in the possession of law enforcement, along with multiple days of other interviews. Well, once we start talking about missing information when it comes to Brad Holder, a known Odinist, it's going to be interesting because they're still thinking about going down that lane. Number 3, on March 18th, 2024, a hearing was held on said matter. 4, at the March 18th, 2024 hearing, Steve Mullen, investigator for the prosecutor's office, testified that other evidence was destroyed in 2017 as well, as it purportedly, unintentionally was taped over. Unintentional, you say. 5, furthermore, at said March 18th, 2024 hearing, the defense tendered Mullen's undated reports that purportedly explained how the evidence was destroyed. Whoa. 6, the prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecution. On April 2nd, 2024, this court issued its ruling denying the defense motion to dismiss the charges. 8. Since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and or potentially useful evidence that the prosecution is not turned over to the defense, is missing, or that the state of Indiana has destroyed. 9. Just like Allen's first motion to dismiss, the missing/destroyed evidence relates to third-party suspect Brad Holder. Oh, his name's all through this. So, Brad Holder's missing phone extraction data. 10. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17th, 2007. 11. The prosecution has not turned over any data extractions, reports, or evidence from Brad Holder's phone. 12. Curiously, on the same day and at the same time that Brad Holder believes that he turned his phone over to law enforcement officers, his son, Logan Holder, also turned over his phone, Logan Holder's phone. 13. The prosecution has turned over the data extracted from Logan Holder's phone, but not any data extracted from Brad Holder's phone. 14. While the data from Logan Holder's phone was extracted, law enforcement apparently claimed that law enforcement, failed to extract data from Brad Holder's phone, even though both he and his son turned over their phones to law enforcement at the same time. 15. Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. Holman, May 3rd, 2024, deposition lines 13 through 15. 16. When asked if he, Holman, would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal. Depends on circumstances, but I think you would have to ask the FBI what they did. This is from Holman's May 3rd, 2024 deposition, page 6, line 22 to 25. 17. Finally, after being pushed by the defense, Holman finally conceded that he would have extracted data from Holder's phone if he was given the opportunity. Again, this is in his May 3rd deposition, page 7, lines 8 through 12. 18. The defense finds it highly, highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at the time, and no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. He had been dating Abby Williams. Logan had. 19. On February 17th, 2017, documents specifically sought by the defense Doug Carter's emails with the FBI provided evidence that A, Brad Holder was a suspect within days of the M's, and certainly on February 17th, 2017, when Holder was interviewed at the Delphi police station and turned over his phone to law enforcement. B, State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C, even the top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. D, Logan Holder was not mentioned as a suspect in these emails. This begs the question, this is number 20. This begs the question, why would law enforcement take both Brad Holder's phone and his son Logan Holder's phone, but only extract data from the son Logan Holder when he was not a suspect, but would not extract data, any data, from Brad Holder's phone when he was an actual suspect? Jazzy saying, hello, hello, hello. Hello to her fans. Alrighty, so 21. Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the M's. 22. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they said they had his phone in their hands on February 17th, 2017, and he was a suspect at that time? 23. The defense believes that the above information provides strong circumstantial evidence that law enforcement did extract the data from Brad Holder's phone on February 17th, 2017, but had not turned it over to the defense. 24. Logic and common sense support this belief. 25. If law enforcement failed to extract Brad Holder's phone and data while it was in their very capable hands on February 17th, 2017, then the only other explanation... Oh, give me 2 seconds. Get back, ladies, get back. Let's see if I can... All right. So 25, if law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands, then the only other explanation would be that law enforcement... You hear the noise, guys? Okay. So the only other explanation would be that the law enforcement was completely and utterly inept. All evidence of Brad Holder's second interview with law enforcement is missing. You guys, good God. How are we ever going to know who really did this? 26. Additionally, Brad Holder testified in his deposition that in addition to law enforcement's February 17th, 2017 interview, which was purportedly accidentally taped over, that law enforcement conduct a second interview of Brad Holder sometime later, probably within a year or two of his first interview. 27. Holder further testified at his deposition that A, law enforcement conducted the second interview at the Logansport police station. B, the interview took about an hour and a half. C, the interview was likely videotaped in an interview room. D, the interview involved much questioning about Patrick Westfall. Now, he is supposed to be the head of the local Odinism, I don't know, what would you call it, chapter? He's supposed to be the head honcho. 28. After the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone, and B, no evidence whatsoever in the form of video, audio, reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport police station. 29. On May 13th, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport PD and have no record, oh lordy, no record of Brad Holder's phone being downloaded. 30. At a recent deposition, when Unified Command's Jerry Holman was asked about how the defense could obtain any information about the second interview, Holman said he had no idea, but encouraged the defense to reach out to the Logansport PD to find out. This is via the deposition on page 5, line 20 to 25, and page 26, lines 1 and 2. 31. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is the requirement of law enforcement. 32. Also, at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met victim Abby Gail Williams, remembering that his son dated her. And that one of Brad Holder's times of meeting Abby Williams, oh my God, took place at Patrick Westfall's house. See how tight this community is, you guys? 33. When Jerry Holman was confronted with Brad Holder's ever-changing stories concerning how many times Brad Holder had met Abby Williams, Holman stated, "Perfectly reasonable, in my opinion, that he remembered somebody's insignificant. If you have only met them twice, you may not remember that. So I don't see exactly what you're asking me." This was, again, Holman deposition, page 4, lines 1 through 15. Emphasis added. 34. When Holman was asked if it were likely that Brad Holder would not remember meeting Abby when Holder was asked 3 days after the murders at his February 17th, 2017 interview, but then 7 years later he would remember meeting Abby twice, Holman responded, "Possibly, yeah." Holman's deposition, page 4, lines 16 through 21. 35. Holman showed no curiosity nor interest whatsoever about why Brad Holder's stories have changed. This attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects. 36. Patrick Westfall was interviewed on August 17th, 2024, and law enforcement extracted data from Westfall's phone. 37. The phone extraction shows that Westfall's phone had no data prior to August 11th, 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed a week later. 38. In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after police contacted him on or around August 11th, 2023. The only data found on Westfall's phone was between August 11th, 2023, on or about when police contacted him, and August 17th, 2023, when he was interviewed. No texts, videos, photographs, email messages, nor any other data existed on Westfall's phone before the day the police contacted Westfall on August 11th, 2023. What a mess. Just what a mess. This should be a fairly straightforward deal. Was Richard Allen there or was he not? Was Brad Holder and that Odinist group there? What about Keegan Kline and his dad, Tony? I don't know which direction this is going at this point, because there's honestly so many people that are suspicious in that direct area that it's tricky, especially when you have law enforcement hiding, allegedly, destroying, allegedly, information, interviews. If this is the case, I really hope that we end up with a superior court looking at this case again if things don't smarten up. 40. Again, Holman's attitude towards third-party suspect Patrick Westfall supports the defense position that law enforcement was intentionally providing missing evidence, such as Brad Holder's second interview, as well as other items identified in this motion. They have not acted in bad faith or have not provided the missing interview. 41. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if he, Holder, would allow the state police to extract data from his phone, even though it was clear that Holder had bought it with him, had brought it with him to the interview. Wow. 42. Therefore, it is not known whether Holder similarly hid or erased data from his phone, like it appears Westfall hid or erased data from his phone. 43. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. It is also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. Now, Elvis Fields is supposedly another person that is affiliated with this Odinist group, allegedly. 45. It's also curious as to why Vito failed to ask Brad Holder one single question as to incriminating statements that Amber Holder attributed to Brad Holder that are detailed in Frank's 1. 56. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense contention that law enforcement is acting in bad faith. Mimicked crime scene image. Oh, Lord, I remember this. Mimicked crime scene images found on Brad Holder's social media is lost. I should take a look because a lot of the stuff that came out, I've got the photos of still, of the mimicked crime scene. And this was off Brad Holder's Facebook for quite some time. It stayed up. 47. In addition to Holder's 2017 missing phone extractions and missing evidence of Holder's second interview at the Logansport police station, as well as Holder's taped over first interview from February 17th, 2017. Another key piece of evidence is also missing: the mimicked crime scene photos that was on Brad Holder's social media pages, and they were there. I'm going to look in a bit here. I'll look after this. 48. Trooper Purdy viewed the mimicked crime scene images on Brad Holder's social media page sometime in the spring of 2017. This image was marked as Exhibit F in Purdy's deposition and discussed on pages 79 through 81. 49. This mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. And that's fact. 50. In the mimicked crime scene image found on Holder's social media page, the bodies of two women appear to be staged, lying on the ground in the woods with branches laid across their bodies. 51. One of the women in the mimicked crime scene image found on Brad Holder's social media page has her arms staged position in a similar manner as one of the victim's hands were staged and positioned in this case. 52. At the time that Trooper Purdy observed the mimicked crime scene photos on Brad Holder's social media page, the general public did not have the knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that branches and sticks were arranged on their bodies. 53. In an April 12th, 2017 report from Trooper Ryan Winters, it was learned that state police also came into possession of the mimicked crime scene image through an internet sleuth named Ryan. Is that Boucher? Boucher? 54. Boucher. I'm not sure, you guys. I'm going to go with Boucher, although I think it's wrong. So 54, Boucher alerted Winters to the disconcerting images on Brad Holder's social media pages, then sent the images to Trooper Winters over the internet. 55. On April 12, 2017, Trooper Winters then shared with Jerry Holman his, Winters, knowledge of the mimicked crime scene images found on Holder's social media pages and the other information. 56. Because of the similarities between the images that Boucher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. 57. Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Brad Holder was only interviewed in August of 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. 58. To this day, the prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media back in 2017. 59. Fortunately, because internet sleuth Boucher had saved the image that he had turned over to Trooper Winters, the defense team was able to drive to Georgia and retrieve that image. I'm sure I've got those images still. 60. Okay. When deposed, Trooper Winters claimed that state police would not access the images that Boucher found on Holder's social media, that Boucher then turned over to the state police. Winter deposition, August 23rd, 2023, page 9, lines 20 through 23. 61. How could state police lose such an important piece of evidence as an image found on a suspect social media platform that mimics the crime scene? 62. The defense again would not proffer that the mimicked crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence would not be lost by the state police. 63. The defense is filing simultaneously herewith its memorandum in support of its second motion to dismiss based on newly discovered, destroyed, and or missing exculpatory evidence. It's really not looking good for law enforcement in that area, in my personal opinion. I just think that everyone is so sketchy. 64. As detailed in said memorandum in the defense, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. 65. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that law enforcement intentionally or acted in bad faith regarding the destroyed or missing evidence. Just what they need in this case. Missing and destroyed, missing and or destroyed evidence. Oh my God. Another shite show, guys. The exculpatory nature of the missing evidence. I'm going to hydrate. So the list of missing evidence that the prosecution has not turned over to the defense includes I see Brad Holder's name through there pretty consistently, guys. So a video of Brad Holder's first interview. This is stuff that has not been turned over. Again, A, video of Brad Holder's first interview from February 17th, 2017. B, video of Logan Holder's interview from February 7th, 2017. C, data from Brad Holder's phone extraction from February 17th, 2017. D, video from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. E, audio taken from Brad Holder's second interview with law enforcement taken once again at the Logansport police station sometime in 2017 or 2018. You guys, how is it that all of this stuff is destroyed, missing, whichever way it turns out to be? How is this even a possibility? We're talking about a federal crime. This person whoever it turns out to be, or possibly more than one, they unalived Abby and Libby. Their families need justice. It's disgusting to see that the possibility is even there that law enforcement is crooked. But, we've seen it before, haven't we? Look at the Karen Reed case that we're watching right now. So E, audio taken from Brad Holder's second interview with law enforcement, taken from the Logansport police station sometime in 2017 or 2018. Any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport police station sometime in 2017 or 2018. G, mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page. It was there. I've seen it with my own eyes. H, images Ryan Butcher sent to Trooper Winters on April 12th, 2017. 67, notice that all missing items are related to third-party suspect Brad Holder. 68, also note that the prosecution is asking that the defense not be allowed to ever mention the name Brad Holder during trial. Are you kidding me? Are you kidding me? Now that is not sus at all, is it? 69, currently the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution to turn it over, or upon the prosecution realization that the defense would soon be learning about the existence of said evidence, includes A, Todd Click letter and accompanying 85-page report. The prosecutor held on to the evidence for over 4 months until he knew the defense would learn of its existence. They're saying here multiple Elvis Fields interviews. Because I have not seen any interviews of Elvis. C, Rod Abrams interviews. D, multiple Johnny Messier interviews. E, multiple Taylor Hornaday interviews. F, Ned Smith interviews. And G, Libby German's phone dump. Are you kidding me? Now, if the defense does not have Libby's phone dump, oh, lordy, lordy. That phone holds the key to a lot of different activities as far as this case goes. They need that phone. They need that extraction. 70. Notice that all items, again, paragraph 69, are related to third-party suspect and Odinism. 71. Also, note that the prosecution is asking that the defense not be allowed to even mention any of these third-party suspects or Odinism during trial. You know what, though? Between Slick Nick and Francis C. Gull, they have made this very, very hard on the defense to the point where I believe it's criminal. 72. The evidence that the defense does have in its possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answers concerning a very basic questions. Question: how many times he had met Abigail Williams? Now that should be an easy ask if this young lady was dating his son. 73. According to the only police report that memorialized Brad Holder's accidentally destroying first interview, Holder stated that he had never met Abby Williams. 74. At the time that he was first approached by law enforcement, which was February 17th, 2017, and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity in time that Brad Holder's son dated Abby Williams. Logan Holder was dating Abby Williams at the time of these murders. And B, the enormity of the situation, i.e., two girls had been and one of whom dated Brad Holder's oldest son. 75. If Brad Holder is in any way involved in these murders, as the defense believes, the evidence strongly supports then Brad Holder's claim, close in time to the deletings, that he had never met Abby Williams is understandable. Denying that he, Brad Holder, had never met Abby Williams could, in Holder's mind at least, cause the police to take their attention off of Brad Holder. Okay. Oh, give me 2 seconds. Okay. So, 76, if at his February 17th, 2017 interview, Holder was telling the truth that he never met Abby Williams, then his answer to police when asked the same question, even 6.5 years later, on August 30th, 2023, should be the same. I never met her, because a father would definitely remember if he had ever met his son's girlfriend who had been M'd. Conversely, a father would know if he had ever or never met the girlfriend of his son involved in a high-profile case. 17. However, if at his February 17th, 2017 interview, Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he told law enforcement 6.5 years. Oh, let's see. And back I am. So, 78. At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that he had, in fact, met Abby one time. 79. Either Brad Holder intentionally lied to police in 2017, closer to the time when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby Williams, but then somehow remembered meeting 6.5 years later. Jesus. 80. Then at his May 2nd, 2024 deposition, Brad Holder provided yet a third different answer. He said he had actually met Abby Williams 2 times. 81. Furthermore, at his May 2nd, 2023 deposition, Holder remembered that one of those meetings occurred at Patrick Westfall's house. Again, this is in the Holder deposition on page 20 and 21. 82. Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items, A through H, detailed in paragraph 66, are exculpatory in nature. 83. When combined with the evidence obtained on Brad Holder's social media pages, including images of a ruin inked onto Holder's hand that mimics the way the sticks are formed on Abby's body, as well as the other evidence details in Frank's Motion 1. The ever-changing stories of Brad Holder on the simple topic of how many times did you meet Abby Williams should all provide insight into why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? 84. It would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the many missing items would contain obvious exculpatory evidence. 85. The defense believes that it has shown that the missing/destroyed evidence is exculpatory in nature. The missing destroyed evidence is exculpatory, but even if the court disagrees, the court should find the missing and destroyed evidence as potentially useful and dismiss the charges. 86. As detailed in the accompanying memorandum, if the court finds that the missing/destroyed evidence is not exculpatory but does find that it is potentially useful, then the court should dismiss charges if it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith regarding the missing evidence. 87. Frank's 1. 1 through 4 provides many details as why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. 88. The defense incorporates the context of Frank's 1 through 4 in this motion. 89. Provided below are a few facts that support the defense contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or failed to return over said evidence to the defense. A. Missing portions of vital video from Jerry Holman's October 26, 2022 interrogation of Richard Allen. So number 1, Jerry Holman interrogated Richard Allen on October 26, 2022, and said interrogation was videotaped. 2, however, the first few minutes of the interrogation are inexplicably missing. 3, the missing portions of the video, according to Jerry Holman, would have shown Holman discussing Richard Allen's Miranda rights and freedom to leave the room, both important concepts that might support the legality or illegality of Holman's interrogation. There's quite a bit in here. I don't know how much of it is factual and how many of it is possibly the defense grasping at straws, as some think. But, if any of this is true, that all of this evidence is gone, how are they even going to prove that he is guilty? How are they going to do that when there is so much missing? And how are they going to be able to absolutely rule out these old nests that seem to run around that area. Okay, so 4. No explanation exists as to why the only portion of the videotaped interrogation that is missing is the crucial beginning of the interrogation. The missing video supports the defense contention that Holman knew he had screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed. Wow. 5. The missing video from Holman's October 26 interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence in bad faith. Yeah, I can see Fran Siegel just tossing this. Anytime there's questions, she doesn't deal with them, she just tosses it. B. Jerry Holman lied in his August 10, 2023 deposition that Brad Holder was never a suspect. 1. In his August 10, 2023 deposition was when asked if Brad Holder was ever a suspect, Holman said the following: "Not really, no." In Holman's deposition, page 172, lines 4 and 5. 2. However, it is clear from the reviewing emails between Doug Carter and the FBI that Brad Holder was a suspect very early on in the case. 3. As stated before, Holder was thought to be a suspect and his name was known as a suspect at the highest level of the state police, Superintendent Doug Carter, and even known to Indianapolis, one more time, Indianapolis top FBI agent Jay Abbott. 4. The fact that Holman misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. C. The prosecution failed to turn over the Todd Click exculpatory evidence for 4 months, and then only turned it over after it was obvious that the defense would be learning of the existence of the Click letter. 1. As detailed in the Franks 1 and numerous other pleadings, the prosecution chose to not turn over exculpatory evidence from May 1st, 2023 until September 8th, 2023 of a letter from Todd Click and 85 pages detailing his investigation. 2. Contained in the Click letter was evidence that 3 law enforcement officers who investigated the case believed that third-party suspects, Brad Holder, Patrick Westfall, and Alvis Fields, were involved in these passings, and Click believed that the evidence supporting their involvement in the M's was much more compelling than the evidence against Richard Allen. We just want the right guys or the right guy. That's all. It should not be this difficult. 3. As stated in a previous pleading, it is hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers essentially believed the wrong man may have been arrested. 4. The fact that the prosecution refused not immediately to turn over exculpatory Click letter for over 4 months is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. D. The prosecution failed to turn over exculpatory evidence contained in several videotaped statements until after the prosecution knew that the defense would soon learn of their existence. 1. As detailed earlier in this motion and in the Franks 1, the prosecutor failed to turn over several videotaped interviews that provided exculpatory evidence concerning third-party suspects until after it was clear that the defense would soon be learning of the existence of those videotaped interviews. 2. The prosecutor turned over these videotaped interviews nearly 9 months later than required under rule and statute. 3. Those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies told by third-party suspects concerning their knowledge of other third-party suspects. 4. The fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of the third-party suspects in committing the M's until after the defense would soon learn of their existence is evidence of the intentionality of law enforcement involving the concealment of evidence and/or evidence of bad faith. E. The prosecution and law enforcement attempted to conceal the identity of a Purdue professor whose testimony contradicted the sworn statement of Jerry Holman. Remember that, guys? And they found that professor that law enforcement said that they were never going to find. 1. This matter has been detailed in Franks 1, 2, and 3, and in various other pleadings previously filed. 2. At his August 10th, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out that persons practicing Odinism or some type of cult had committed the murders was because a Purdue professor had ruled out such a possibility. This was in Holman's August 10th, 2023 deposition, page 6, lines 7 through 20. 3. However, after reviewing the Purdue professor's report prepared on or about March 1st, 2017, as well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor never made such a claim as Jerry Holman stated in his deposition. Whoa. 4. Furthermore, at his deposition, the Purdue professor, whose name is Jeffrey Turco, specifically denied that he ever made the very statement that Holman attributed to Turco. This is Turco's deposition, page 65, lines 7 through 25, and page 79, lines 18 through 25. 5. Additionally, the prosecution told the defense in September, we might have to, and we're back. Sorry about that. Okay, 5. Additionally, the prosecution told the defense in a September 6, 2023 email that the identity of the Purdue professor was still unknown and may not ever be able to be found. That was untrue, as Jerry Holman had already learned of Jeffrey Turco's name weeks earlier. Whoa. 6. Additionally, the defense learned that the actual Purdue report from March 1st, 2017, which also contradicted Holman's deposition testimony, was in the possession of law enforcement since that time, but was purportedly rediscovered by law enforcement in August of 2023. The prosecution finally produced said report to the defense on October 4th, 2023, and only upon requests of the defense again. 7. Jerry Holman's August 10th, 2023 deposition testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality of attempting to conceal evidence and or evidence of bad faith. 8. The attempt of law enforcement and the prosecutor to conceal the identity of the Purdue professor is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. F. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. 1. A key piece of evidence in the case is the phone data extracted from Liberty German's phone. 2. The prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. 3. However, the defense did not receive that evidence until September 8th, 2023, almost 9 months later than required under criminal rule. 4. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the passings. 5. The failure of law enforcement to turn over Liberty German's phone for nearly 9 months. What is that? Whoa. Thereby concealing exculpatory evidence the defense could have been exploring from the beginning of the representation is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. G. Law enforcement concealed the Blocher report until April 26, 2024. So, what, a month ago? Damn near? Unreal. These young girls were found unalive on February 14th, 2017. Why are they just getting some of this information now? So on April 26, 2024, the state of Indiana turned over a report from which Steve Mullen concerning the findings of Sergeant Mitch Blocher of the Indiana State Police. 2. Contained in the body of that report was exculpatory information concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017. Thirdly, the failure of law enforcement in turning over this report for well over a year beyond what the prosecution was required to turn it over, and only after the defense sent a certified letter and filed a motion to compel and for sanctions, demanding that the prosecutor turn over certain evidence, is further evidence of intentionality and attempting to conceal evidence and or evidence of bad faith. It's not looking good for law enforcement out in the Delphi area. It's not looking good at all. So H. Toby Lesenby contradicted the sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people involved in these deaths. 1. The matter is detailed in Frank's 1. 2. Both Liggett and Holman testified under oath that only one person, Richard Allen, was involved in the deaths of the victims. 3. This proclamation, under oath by Liggett and Holman, would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in these M's. 4. However, when Toby Lesenby was deposed, he, Lesenby, stated under oath that Tony Liggett actually believed that multiple people were involved in these deaths. And 5, this conflicting sworn testimony of law enforcement is further evidence of intentionality on the part of law enforcement to conceal their actual beliefs concerning the number of people involved in their deaths of the victims in order to direct the defense away from theories that Odinists were involved in these deaths, and additionally is evidence of bad faith. No recordings of Richard Allen's interview with Dan Doolin exist. 2017, Dan Doolin has stated that he, Doolin, knew that he had audio recorded interviews when conducting interviews of tips and leads. This is in his deposition, Doolin's, page 55, lines 18 through 25. 2, Doolin claims that he now believes that he never audio recorded interview of Richard Allen. I think I must not have audio recorded it because all the other ones that I had are in file on my computer. And I listened to each one of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. Doolin's deposition, page 56, lines 2 through 9. 3, this interview is crucial, as what Doolin claims Allen told him. Doolin helped establish the timeline used to secure a search warrant to arrest Allen. 4, the defense believes that Richard Allen was tape recorded and that the missing tape supports intentionality on the part of law enforcement and or evidence of bad faith. J, missing mimicked crime scene image. This was detailed earlier in this motion and in Frank's 1. 2, the fact that this incredibly exculpatory piece of evidence cannot be accessed and therefore is still missing, causing them to travel to Georgia to obtain said image, is evidence of intentionality on the part of law enforcement to conceal exculpatory evidence and or evidence of bad faith. 90. Brad Holder is a key third-party suspect, yet Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence that supported Holder's involvement along with other third-party suspects identified in the Franks 1. 91. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. 92. Furthermore, law enforcement claim apparently they never extracted data from Brad Holder's phone when they extracted data from at least 101 other phones from people who weren't even suspects, like Holder is. 93. Furthermore, law enforcement claim apparently that they never extracted data from Brad Holder's phone when they extracted data from Logan Holder's phone, which was turned over to the police at the exact same time. 94. Furthermore, law enforcement has turned over zero evidence of Brad Holder's second interview conducted at the Logansport police station, and the defense only learned of said interview through a deposition of Brad Holder's conducted on May 2nd, 2024. Slick Nick, I tell you what, guys, I don't trust him. 95. Furthermore, law enforcement claim that they cannot access the mimicked crime scene photo that was on Brad Holder's social media page. Oh, Lordy. 96. All of the issues of the missing evidence surround one person, Brad Holder and Odinism, which the prosecution is also attempting to block the defense from even mentioning at trial. 97. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of a third-party suspect is missing. I don't know. I get more and more doubt in me about his involvement, about Richard Allen's involvement. I don't know yet, obviously, but there's so many other questions. 98. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn over much of the evidence that the defense does in fact possess concerning third-party suspects for 9 months or more, and only after the prosecution knew that the defense would soon be learning of the existence of a third-party suspect evidence. 99. The bad faith of law enforcement and prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. 100. Because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed. 101, our last one. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require that charges against Richard Allen be dismissed. Wherefore, pursuant to the law detailed in this memorandum in support of this motion, as well as the facts contained in this motion, the defense requests this court to dismiss all charges against Richard Allen. Respectfully submitted, Andrew Baldwin. Baldwin, Perry, and Wiley. And this is to certify a copy of foregoing pleading has provided to all counsel of record for the opposing party via IEFS the same day of filing. So, guys, there's a lot. There's a lot. Now, whether or not Richard Allen actually did this, I can't say. I honestly, at this point, I cannot say. But I will say that there is a lot of very suspicious things going down in Delphi and that surrounding area, whether it's cops looking a little bit stinky or if it's the fact that there's possible Odinists all over that place, including in Westfall, right? So, guys, thank you ever so much for spending the time with me. I appreciate you. You know I do. And I will see you guys really soon. Tomorrow, Karen Reed, 6:55 Mountain Standard. I'll see you there. Bye.